including several teen girls right here in Massachusetts. And we've also heard from several former child brides from around the country with heartbreaking stories about how much pain and suffering they feel they could have avoided if they hadn't been married so young. And we've also compiled extensive legal and social science research that shows how easy it is for forcing child marriages to happen under current laws and how likely it is that any marriage entered under age 18, even if voluntary, will put a child at great risk of harm. So I speak today in strong support for these bills, and I want to convey 3 key points. As you've heard, these bills address a serious problem. Nearly 1,200 children under age 18 were married. Most were girls with adult men, and many of the men were significantly older. Children as young as 14, younger than the legal age of consent to sex in Massachusetts, have been judge-approved to marry. Marriage licenses have been issued, where protective orders and arrest warrants should probably have been issued instead. And so while we don't know all the stories behind these stats, here's what we do know. Every single one of those 1,200 children, whether the marriage was forced or voluntary, and whatever their age, was put at acute risk for harm in those marriages and in their lives. Sky-high divorce rates, sharp school dropout rates, much greater risk of poverty, a slew of medical and mental health problems. And we know that financial dependence is one of the main reasons that domestic violence victims cite for remaining with or returning to their abusers. My third point, every single one of those 1,200 children, if they were facing a forced marriage, as you've just heard, would have been disempowered to prevent it because of their legal status as minors. They can't just run away from home, they can't go to any shelter, and the shelter that takes them in can only keep them for 72 hours, and the list goes on. So when self-help is foreclosed to them, children have to depend on DCF intervention, and in our experience, DCF rarely acts, or when they do, they may make the matter worse, and this leaves the girl to 2 terrible choices. She feels she either must give up and submit to the marriage, or, as so many of our clients have done, they may contemplate suicide as the only other way out. That concludes my testimony, but with your permission, I want to share a short audio clip of a client of ours speaking about the forced marriage she was compelled to enter at the age of 16. May I play the clip?
How long is it?
It's 2 minutes and 22 seconds, and very compelling. Thank you.
You're welcome to come in anytime.
I have it on a thumb drive, and I can provide it to the committee for their listening.
Yeah, we're happy to make sure we get it at some point.
I'm sorry.
No problem.
Thank you, Chair, Councilmember Chairman. My name is Melinda Appleheart. I am with Greater Boston Legal Services, and I'm here to speak to my representation of forced and urban marriage victims in the Commonwealth. My first contact with a forced marriage victim was back in 1993. My client presented at Greater Boston Legal Services with a really severe case of domestic violence that we learned also involved severe child abuse with injuries sustained by the child. I represented her successfully.
A little bit, we can't hear you.
You know, try pulling
Like right up here and really talk right into it, that'll work.
Okay. Domestic violence case, I successfully represented her in a divorce, child custody, and 209A, and an appeal to the SJC when I knew I was a soft talker, but I thought the harm to this family was over after GBLS represented her in these cases, but I was wrong. I learned years later when a young woman came into my office homeless and scared that she had been forced into marriage to her first cousin by my former client in concert with her former mother-in-law. So these 2 kids were forced into marriage. They were 18 when they were married, but didn't have the ability to refuse, didn't have the self-confidence to walk away from the marriage. Imagine the impact on a minor if an 18-year-old can't walk away from a forced marriage. I represented 2 sisters who fled to Massachusetts from another state The older of the two had been forced into marriage in a minority, but wasn't free to leave, to break away until her majority. They were also facing the impending forced marriage of her 19-year-old sibling, who was developmentally and intellectually disabled and had the capacity of a 13-year-old. Clearly clearly was incapable of consent. Finally, not too long ago, a 14-year-old student, 14-year-old student went to her guidance counselor and revealed that her parents were bringing her abroad during school vacation to become engaged. That may not sound dangerous, but what engagement meant in her family was, at the age of 14, she was committed to an older man she didn't know and she didn't want to marry. That marriage may occur before the age of 18 or it may occur at 18, but she had no choice and no voice and didn't want to go abroad over school vacation. These bills would empower students like her to say no, to say, I can take action. Thank you.
Thank you very much for your testimony.
Good afternoon. I'm Maria Masidas, and I serve as the child advocate for the children of Massachusetts. I think I wanted to join the senator and representative in how shocked I was, and most of my colleagues, to understand that there was actually no limit, no lower level in terms of when children could be married in Massachusetts. Our current statute only requires that the judge confirm parental consent on the marriage of a youth under the age of 18. No further inquiry is required, no exploration of whether the proposed marriage is coerced or forced on the youth, no determination if the marriage is in the best interest of the child. We currently have no bench books in the courts that approve these petitions, and no evidence is taken whatsoever with respect to protecting the children. As the Commonwealth's child advocate, I am concerned about the safety and healthy development of all of the Commonwealth's children. We know from the best science that someone's chronological age, in terms of the best knowledge of brain science, is no indication of the child's ability to make decisions. And we know from other statutes, and this legislature has recently made changes in terms of increasing the age of youth in criminal matters, that children need the protection of the Commonwealth. We know that for many children who were married young, that their outcomes are not as good as children who wait until majority. In addition to all of the legal protections that these children sacrifice, minors cannot stay in shelters for victims of domestic violence without a parent. Minors can't file for divorce, annulment, or seek an abuse protection order without a guardian being appointed for them. We believe that raising the age of marriage to 18 is the best choice. This permits the youth to have all the rights and protections accorded to an adult, permits the completion of their education, and permits the youth to resist family or community pressures to take action that they are not mentally ready to make. So we urge the committee to please support both of these bills.
Thank you so much for your testimony. Are there questions from members of the committee? Very good. Thank you very much for coming in. So now, I believe nobody else on this subject of child marriage, am I right? Very good. We're now on to the next subject, which is healthcare proxies. We have several bills pending, and I see at least see Brendan Abel from the Mass Medical Society.
Good afternoon, and thank you for the opportunity, and thank you for your patience. My name is Brendan Abel, I'm from the Massachusetts Medical Society, and I'm here to testify in strong support of Senate Bill 783 and House Bill 3093 in Action for Medical Decision Making. These bills, in short, would provide a better solution for patients without capacity to make healthcare decisions for themselves. so long as the patient does not have an existing healthcare proxy, by allowing the attending physician to appoint a family member or friend as a surrogate decision maker. I submitted extensive written testimony, but I want to make a couple of quick comments. First, this does not change the gold standard of the healthcare proxy. And further, this does not replace the ability of the courts to appoint a medical guardian. This bill simply identifies a middle pathway for those without a healthcare proxy, but where the delay and the expense of the courts is not necessary given the nature of the decision and the availability of a family member or friend. Second, we take very seriously the notion of patient protection. In this bill, there are important criteria built to ensure that surrogate decision makers appointed by their physician have the type of relationship with the patient that allows them to make the best decisions on behalf of the patient, and to ensure that the scope of the decisions that can be made by this decision maker are limited to exclude, for example, extraordinary medical decisions and transfers to psychiatric care. Third, we now have evidence that this bill would work. 2 major academic teaching hospitals have looked at this bill and have gone back through the charts where they have had to seek judicial appointment of medical guardians, and have learned that nearly half of all guardianship proceedings at the probate court could have been avoided with no change in the resulting appointed decision maker. So we know that this bill would reduce the several day delays that take place all the time in hospitals when they're seeking judicial appointment of medical guardians in hundreds of cases per year across the Commonwealth. In the instance of a patient ready to move to a skilled nursing facility, for example, keeping them unnecessarily in a hospital bed wastes money, and it keeps the patient away from the rehabilitation that they really do need. So lastly, I'd note that this bill only works for patients who are fortunate enough to have family or close friends to serve as a surrogate decision maker for them. We know that this does still leave a vulnerable subset of patients without proper surrogates, and for these reasons, we do strongly support House Bill 3027, an act to establish the Office of Adult Decisional Support Services, which would create an office to facilitate the network of skilled, trained volunteers to serve as surrogate decision makers for those who do not have a close friend or family member to serve on their behalf. We believe that this would complement our bill nicely, and together they would substantially improve the medical decision-making options for patients in Massachusetts in the unfortunate event that they lose capacity, and again, they do so without already having a healthcare proxy in place.
Thank you very much for your testimony. Senator Green.
I just appoint, I filed the bill, the Senate bill, which would effectively do the same thing.
Okay.
For some reason, it went to public health. So, I know there's been, Representative Broder, thank you for working on it. I actually don't know why one went into one place and went the other. I think we should look into that, but I obviously, as the Senate side, I'm very supportive, and it's almost an identical bill that she's going through.
Okay, well, good to know. We can follow up and try to consolidate those.
We will as well. Thank you.
Any other questions? Thank you very much for your testimony. Appreciate it. Dana, Dana from the Massachusetts Association for Mental Health. Is that you? Please come forward. Healthcare proxies, in that space generally, an act relative to improving access to emergency treatment plans. That's fine.
If there's no...
Why don't you give your testimony in the summary way? I mean, I appreciate your respect for the committee's time, but just so we know why you're here, just in the summary. Go ahead. Just out of curiosity, anybody else here testifying in 833? So that's what you know. That's what you say is what we're going to do.
Good afternoon. Thank you very much, Mr. Chairman and Madam Chair. I'm Don Walsh from the Massachusetts Association for Mental Health, and I'm testifying today in my capacity at MAMH, but also as someone who has 20 years of experience in state government agencies in Massachusetts and Rhode Island, being responsible to direct mental health, substance abuse, and forensic medicine services. Another 20 years in private healthcare organizations managing healthcare to people with complex health conditions, including mental health and substance use conditions, and work monitoring on behalf of judges and courts, implementation of reforms to forensic services and to mental health services in the District of Columbia and the state of Washington. I'm concerned about the legislation for several reasons. The legislation certainly comes in the context of a situation in the Commonwealth where we are suffering from long-standing deficits in the care system related to cuts that were endured over a number of years, as many as nearly $60 million in cuts between 2009 and 2014. And despite unprecedented levels of insurance and enrollment in services, we have a number of gaps in our service system. And I think we all agree, including those crafting the legislation, that there is an urgent need, particularly for care to people whose needs are complicated, who may have co-occurring mental health and substance use conditions, and who have often presented themselves in emergency rooms in crisis, sometimes used and repeatedly used inpatient care, but had a hard time connecting to home and community-based services in a consistent way afterwards. I think there's an illusion that compelling treatment is going to solve problems that exist in the comprehensiveness and intensity of the services we're now able to provide in the Commonwealth on a consistent basis. We do have ample evidence that when people can have the advantage of intensive community-based care with assertive outreach and treatment, even people who've been chronically homeless, people who are in the justice system repeatedly, that we've seen great success. Recently, evidence from the community support program to end chronic homelessness that's been presented, and evidence coming from the Worcester program in Worcester, where people with behavioral health conditions and long histories of treatment disaffiliation coming out of the Worcester House of Corrections are engaged very aggressively in services by the Advocates Organization and provided housing and intensive treatment resources.
Thank you, Madam Chair, Senate Chair. I'm Bob Fleischner. I work at the Center for Public Representation in Northampton. We're a public interest law firm that represents people with disabilities. I personally have done scores, if not hundreds, of so-called Rogers hearings, which this bill is addressed and amending a section of the Massachusetts Uniform Probate Code that deals with the Rogers hearings. It also addresses a perceived problem in the Rogers system of orders not being complied with. I need to say, or I want to say, that I'm not sure how significant a problem this is. Of all of the clients who I've represented in the Rogers process, I've never had a client who has not obeyed a court order. There is something about a judge telling someone to take a medication that has a deep meaning and impact on that person. I have one individual I've represented for 30 years in Rogers hearings. He does not believe he has a mental illness. He does not think that the Prolixin that he's forced to take every 2 weeks by shot at his mental health clinic helps him. He does not get any other services of any kind from the Department of Mental Health, yet he shows up every 2 weeks and gets a shot because a judge told him he had to. And that's maintained him, that has helped maintain him in the community. This bill, we believe, would be costly. It creates new responsibilities for monitors, so-called Rogers monitors in the Rogers system. It requires, at least it significantly favors the monitors being licensed mental health clinicians. They're required to file more reports than are currently filed. It would be able to bring petitions, bring to the attention of the probate court judge that there is any kind of non-compliance with the order, either by the individual or by the service provider, and then ask the judge to enter enforcement orders against the service provider or against the individual to somehow force the treatment. Our experience is, as Dr. Monash has just said, that voluntary services work better. They engage people. Involuntary services drive people away from services. They force people or encourage people not to reach out to the mental health system. They draw services away from people who want services and force them on people who don't want them. And the funds that it would take to implement this program would be much better used in increasing the availability of voluntary community mental health services for people with mental illness in the state. So we urge you not to report this bill favorably. And while I'm here, since I have 8 seconds, I'd like to say in those 8 seconds that I also strongly support the bill on decision-making and creating public guardianship commission.
The bill that was previously testified to.
Yes.
No.
That's this, I would call that the surrogacy bill, which I also think is a good bill. This is the bill, you heard about it maybe from Attorney General.
Public guardianship.
Yes, the public guardianship.
Yeah, sorry, no.
My name is Susan Pendell. I'm Senior Attorney with Mental Health Legal Advisors Committee. We're a state agency under the Supreme Judicial Court. I'm here to oppose Senate 833. Basically, while we understand that people are well-intentioned and want to get people services, we do not believe this bill will do that. In fact, we think, as Bob said, that it will drive people away from services. I have been working for over 20 years at the Mental Health Legal Advisors Committee, and my clients are afraid to even get physical health care because of experiences they've had with coerced treatment when they go to a hospital. So I think the money that Bob discussed that would be spent on these enforcement proceedings would be better spent in providing people with a wide array of choices as to their mental health treatment. And the testimony talks about some of the alternative choices that currently are not very well funded in Massachusetts that have been shown to engage people in treatment, including people with serious mental illness. And there is one correction that needs to be made in this testimony, and we will submit a corrected version of the testimony.
Thank you. Look forward to your testimony. Appreciate you weighing in. Any questions for members of this panel? Thank you so much for testifying. Representative Livingston.
Thank you, and thank you for taking out a turn. It was a very busy day, so I'll try to be quick. I'm here to testify about a bill that I filed, House Bill 303, along with the Senate companion filed by Senator Lesser, Senate Bill 885. And it deals, hopefully with not as contentious an issue as some of the ones you've dealt with today, but a very important one. And it's what happens with digital assets after somebody dies, and who has access to them. Right now, Massachusetts doesn't have law on that. There's some federal laws, and this bill would set clear rules in Massachusetts, similar to that have been set in 30 other states, exactly how somebody will tell their service providers who has access to their assets, to their emails, to their social media accounts, after they pass away, and the extent of that access. It will also, and so it gives clear rules to the service providers about that. And so I hope that you favor the report of the bill. If there's any questions.
Thank you so much. Questions from members of the panel? Thank you for your work.
Thank you.
Always
Thank you.
appreciate it. So now we're going to move on to the guardianship question. Mr. Mike Festa, will you sort of testify on that?
Yes. Thank you. Chair Cronin and Chair Brownsberger and all distinguished members of the committee, recognizing your perseverance and interest in a lot of subjects today. I will be brief. I do have written testimony. I'm going to summarize it, but I do want to emphasize a couple of points. AARP, as you know, is a large organization in Massachusetts. We have 800,000 members, and one of the issues that does come up quite a bit that we're very concerned about is striking that balance between respecting a person's privacy and also acknowledging that in the area of guardianships or challenges around making decisions on in medical cases, that there are gaps in the current system. And one of them that you heard testimony from the Mass Medical, we joined with them in strongly supporting Senate Bill 783 and House Companion Bill 3093, improving medical decision-making. We want to go on record strongly supporting it, and I would just summarize by pointing out that the physician effectively is going to be in a place where they've been dealing with family members throughout whatever is happening at the hospital setting. And in order to get right to the heart of the question, what are we going to do at this moment, and not suddenly stop and go into a guardianship proceeding, costly, timely, etc., and knowing in circumstances where there is no healthcare proxy in place or an advance directive, you've got to address that, and it's a real challenge right now. We recognize that. We think this bill addresses it very well. It puts the priority where it should be, recognizing the physician is in place, having dealt with family and those who express concern and interest in the patient's well-being, to allow them to be in that role of making that decision. I also want to then flip to the other reason why we're here, and that's on House Bill 3027, Representative Broder's bill, and I would point out Chairwoman Cream. And certainly the subject area is the one that addresses the adult guardianship decisional support services. We are very supportive. We think also it fills gaps. Understanding that, right now, we do have a system of guardianship, public guardianship. But those agencies that have that authority, whether it's Executive Office of Federal Affairs, DPS, etc., they only deal with their own clients within that system. There are those who are not in that system, the unfriended that Representative Broder spoke of. These people need to have a voice. They need to have representation. This public-private partnership, I know there's some concern whenever you say, oh, we're creating a new agency within the OEA. Well, the truth of the matter is there are no resources that would be part of the taxpayers' challenge around this. This is done by the public-private partnership. It's a really great model because it does address those folks who are left in a place of limbo legally. And we strongly support it. I do want to end by one quick point. On the first bill, American Bar Association study, which we included in the written testimony, we're only one of 5 states that haven't embraced this surrogacy concept. And I hope we are, after soon, only the 4th. Thank you very much for your time.
Thank you very much for your testimony. Other questions from members of the panel?
Thank you.
Thank you so much. Is David Sontag here? Yeah, I believe. Okay. Diane Glenn?
Thank you, chairpersons and members of the committee, for giving me this opportunity to be here today. I apologize for being here. That's the only, it's going to be less than an hour. I'm here to ask for your support of House Bill 887, an act further regulating the appointment of guardians, filed by Rep. Linsky since 1999 and co-sponsored by my Rep. Representative Murphy. As a family member and advocate for individuals with developmental and intellectual disabilities, I recently completed a fellowship to study the system of guardianship as it relates to these individuals in Massachusetts. My findings have formed the basis of the Mass Developmental Disabilities Council Guardianship Working Group. I welcome the opportunity to share these findings with the committee and all of its members at any time, many of which concern the lack of the serious breach and lack of due process for individuals undergoing guardianship proceedings. This bill addresses the tip of the iceberg. House 887 modifies the language in the guardianship statute to state that parents or someone nominated by parents be presumed to be the proper person to be appointed guardian of an incapacitated person, unless competent evidence is provided to the contrary. The operative word is presumed and not considered. This bill addresses a historical practice of the court to default to appointing attorneys and non-family members as guardians even when family members are available. There are currently no requirements for a guardian to have training of any kind, no certification, no licensing to become a professional guardian, and minimal oversight of guardians other than a self-reporting mechanism for guardianships created since 2009. And there is no complaint system when your guardian is not representing you. Attorneys who are appointed do not have the skills to navigate the system of services for individuals with ID and DD as parents do, and are often paid by the agencies serving these individuals, creating a clear conflict of interest. There are untold numbers of disabled individuals appointed to a small number of attorneys who, by virtue of the caseload and lack of skill, are neglected under this system. My research surfaced many cases wherein family members are denied advocacy and guardianship by the court, and their loved one is isolated from them, a clear violation of human rights. With the growing elderly population of individuals with ID and DD, over 9,000 currently served are over the age of 50, and the explosion of children with autism, and the fact that the system has yet to catch up with the notion that guardianship should be a last resort, the number of folks at risk of being placed under guardianship unnecessarily is growing. This bill would reduce the risk that they are going to be appointed inappropriate guardians. The language of the bill is clear. It doesn't need to be cooked, and it is long overdue. There is no known opposition. I speak on behalf of the families I interviewed, my own loved ones, those who do not have a voice, thousands of them, and especially for Stan McDonald of Sherburne, Massachusetts, an 81-year-old man who has fought for years for the rights of his son to be honored by attempting to become his guardian. Thank you. I request that you move this bill forward quickly, as it has been moved forward in the past, but too late. Thank you.
Thank you for your testimony. Questions from the panel? Thank you so much for your
Thank you.
testimony. When Gerhard, the panel from Greater Boston Massachusetts.
My name is John Ford. I'm an elder law attorney with Legal Services in Lynn for over 45 years. I've submitted my testimony already and commend you to read it. I would just be redundant of the things that Michael Festa and former Attorney General Harshbarger and Paul Brodeur mentioned earlier. We think the time is overdue for a public guardianship in Massachusetts, and the demographics certainly dictate it. I'm also strongly in support of House 3093, the Act Improving Medical Decision Making. Thank you.
Good afternoon. My name is Jennifer Moy. I'm an associate professor of psychiatry with Harvard Medical School. I'm also a geropsychologist at the VA. My opinions expressed today do not represent the VA, although this is certainly an issue that affects veterans who find themselves incapacitated without a default surrogate, no friends or family. I am going to summarize the research I've done, and I've submitted some written testimony that has more details for you. So I've been researching decision-making capacity and guardianship for about 20 years. I was asked to look at a few things in support of this bill. First, how great is the need? We looked at 37 states that have similar public guardianship systems and prorated from that. And we estimate the need between 3,200 and 3,800. Plus there's 1,000 that's already being served. So that's sort of the 4,000, 5,000 number we've already heard today. And I think that's a great number, because to me it says this is a significant problem. We have thousands of people suffering, but it is not huge. It is not insurmountable. This can fix this problem for these people. We also did qualitative interviews and surveys with stakeholders, but also frontline clinicians. So in brief, I just want to summarize and give you a few examples. About half of those we surveyed talked about delays in treatment, delays in discharge, and delays for transitioning into palliative care, waiting for a guardian. So here's an example from a nurse. I've gotten on the phone and begged someone to take someone. We had a 19-year-old with a head injury after a motor vehicle accident. Every day they stay here, they're losing their rehab ability. And we've heard about delays of a couple of days, but I think that is an exception from what we've heard from our clinicians. Here's a social worker. After calling a list of 18 registered guardians to look for a pro bono, all refused. We then had to stand in front of a judge to ask for the judge to appoint. We went through 4 judge-appointed guardians. This all took months. Meanwhile, the patient is waiting. We heard from clinicians that about half the time they said to go ahead and make decisions themselves on behalf of the patient. About 25% of the time, they had to continue what they thought was medically non-beneficial care. And we've heard this one of our judges referred to this as a black market system. You wheel, you deal, you plead, you elect someone. There are some terrific people who serve as pro bono guardians and then not so terrific. A couple of quick examples. We had a guardian one time where she declined to file a petition for advance directives in court because she said she was not going to get paid for her time. Another example from a different social worker, the guardian refused to come to the hospital to get paperwork to sign and file to admit to skilled nursing. The guardian told us, get the janitor to sign it for me. So again, more detailed data with my written testimony. Thank you for your attention to this issue.
Good afternoon, chairpersons, and thank you for the ability of ourselves to be here to testify. My name is Wayne Gerhard, and like John, I've been a legal services attorney doing elder law for over 40 years. And I, in that time, certainly had occasion to see many of my elderly clients who were in this category of unbefriended elders who were at immediate risk of because of diminished capacity. And these risks include things like financial exploitation, homelessness, deteriorating health, and certainly institutionalization in a nursing home when another alternative might have been less restrictive. I wanted to point out that what we're trying to do is fill those needs, that a qualified guardian could have stepped in many of these cases and prevented those risks. And that's why we've worked, as we've all said, for 25 years or more on establishing a quality public guardianship program. And many of us personally have been doing this work and looking at this bill, House 3027, as a vehicle that addresses the need without creating a lot of expense to the state and funding of public guardianship through a private-public partnership. I did want to just point out, just historically, this is a documentation from Scott Archberger dated May 23rd, 1995. It was a seminar that we all went to about guardianship needing effective and appropriate intervention. So it's been almost this month, 22 years. My clients and the folks we're talking about can't speak for themselves, and so I just wanted to tell you at least one story about an elder that I represented, and this is typical. These are elders who fall outside of the slots provided by Elder Affairs. There's only 170 slots statewide, and they get filled, and then there's no more. So Rose was a typical client who had been independent in an apartment for many years. Her adult child started to financially move in with her, financially exploiting her, taking her income, not paying the rent. And she had declined already. She was losing capacity. She essentially got evicted. She was a case that could have been handled by protective services, could have been stabilized by a public guardian through Elder Affairs, but that did not happen. I also, with my remaining time, also want to support strongly Senate 783 and House 3093, which is the Act to Improve Medical Decision-Making that would mesh with our program to provide alternatives for guardianship where less restrictive alternatives would be appropriate. And I am submitting written testimony along with colleagues from Mass Home Care and Mass Advocates for Nursing Home Reform. So again, we all want you to support House 393. Thank you.
Thank you for your testimony. Did you have one more member of your family?
Yes, one more.
Two more, okay.
Thank you to the chairs and to the committee for hearing me today. I'm Eileen Sullivan-Boss. I'm an attorney from West Springfield, but I'm testifying today not as an attorney, but as a guardian. I accepted my first volunteer guardianship appointment 20 years ago. I've been in service in that capacity every day, weekend, holiday, and vacation since. I don't regret it. Our Supreme Judicial Court has described the responsibility of an appointed guardian as awesome, and I take it seriously. I'm going to refer to my notes to stay within the time constraints. I've become a nationally registered guardian, and I maintain that certification by satisfying ongoing educational requirements and reapplying. I joined the National Guardianship Association many years ago, and I've attended their national conferences. That's given me the opportunity to share questions and ideas with professional, agency, volunteer, family guardians, and judges. I've learned ideal guardianship, recommended guardianship practices from the experts. I also have learned that Massachusetts is one of the few states without a guardian, a public guardian, to protect those individuals who are at risk through no fault of their own due to decisional incapacity. And those risks are serious. I know from personal experience, together with people I've been appointed to advocate for, those risks include isolation, relationship violence, incarceration, homelessness, and the risks that go with homelessness, especially in New England. I've also been in situations for individuals who've been denied appropriate health care after a medical determination of poor quality of life. I'm not here to celebrate my contribution to these people's lives as their guardians. I'm here because I want you to know that I feel sick when I think of what would have happened to my people in these situations without someone to speak for them and to advocate for them. Yes, my time is up, and I just need to say that I really advocate for now. It's time. We missed our chance when 190B was enacted, and it's had the paradoxical effect of making it harder than ever to find qualified guardians for people who are both poor and incapacitated. I testified before you years ago, and I urged you to enact a public guardian for Massachusetts. I'm not urging you today, I'm pleading with you. It's time. And I also need to voice my strong support for the surrogate decision maker bill, because if we're serious about guardianship as a last resort, we have to make every other option available, and that's a big one. Thank you.
Thank you very much for your testimony.
Thank you for the opportunity to speak here. My name is Heather Connors. I received my PhD in gerontology from the University of Massachusetts, Boston, and I'm currently the Director of Research at Guardian Community Trust. Throughout the past year, I've had the opportunity to study guardianship programs in other states. Lessons from other states' successes and challenges have been incorporated into the design of this bill. For example, we met with the Director of Public Office of the Office of Public and Private Guardians in Florida, and we learned about their public-private partnership that they employ. The structure of that bill our bill is similar to Florida's model. I've spent much of the past year interviewing guardians and guardianship stakeholders to learn about their experience within the system. Many of us have reported that they've been asked to serve without compensation when no other guardian could be found for a person who lacked capacity. Some respondents discussed the problems that arose for clients who lacked a guardian. I'm going to share a statement from a protective services manager who voiced his frustrations with the scarcity of guardianship slots that are available. I just want to say the hardest part of my work is as these cases get more complex, there's not much for us agencies to do if there's not available resources to help these clients. We can keep going to court, but if there's not a guardian, then there really is no way to protect the elders because the judge can't do anything without an alternate decision maker. He then went on to talk about an elder whose life savings was stolen by exploitive family members. Prior to joining Guardian Community Trust, I was the manager of the guardianship program at Jewish Family and Children's Service in Worcester. I had the opportunity not only to oversee around 60 clients, 34 of whom were protective service cases, but also to field calls from people who were in the community. Very often they were family members, people from representing hospitals or nursing homes, and they were looking for guardians. And they would be very frustrated and very confused when we weren't able to take them because there were no payer sources available. We also found ourselves in the role of information and referral for so many people, often family members and other non-professional guardians who found themselves taking care of vulnerable people. They may have received a notice from the court about a missing document or were being asked to make important decisions, medical decisions by caretakers. And they would come to us for help because they didn't know how to do these things on their own. Even though that wasn't our mission, we often found ourselves walking people through this because it's very scary to appear in front of a judge without the information that you need, especially when you're volunteering for a family or friend to try to help them out. So this bill has been modeled on successful programs in other states. It will create a program that will act as a safety net by providing guardianship services to unbefriended people without the means to pay privately for a guardian. It will offer training and support functions to family, volunteer, and professional guardians, enhancing their capacity to serve. And finally, it will create a mechanism for state oversight, ensuring that care for vulnerable adults is appropriate and well monitored. I appreciate the opportunity to share my experience, and I encourage you to report this bill favorably to help us protect Massachusetts' most vulnerable citizens. Thank you.
Thank you so much for your testimony. Other questions for the panel? Thank you so much for your testimony. Is Jennifer Moy in already? Okay.
What are you?
All right, we're all set then. David Arnold. And Elaine LaCroix.
Thank you very much for hearing me. I feel that this bill is an excellent opportunity to develop a system of guardianship which is different from the present system of guardianship and offers the potential to fix a lot of the problems that we have in the present system. And I wanted to just give an example from my own personal experience. And I would like you to consider what happened in this case and make sure that this bill is written in a way that this kind of thing can't happen. So, I'm already using my time. My girlfriend and I were subjected to abuse by a GAL and professional guardian appointed by the court. Gretchen had Parkinson's disease and dementia. I moved in with her to take care of her so she would not have to go to a nursing home. Her neurologist said she needed to stay very physically and socially active or she would go downhill, and all Gretchen's doctors said she should stay at home under my care. I filed a petition for guardianship. The court issued a temporary order giving me authority to manage Gretchen's daily care and finances pending resolution of the case. The judge appointed a GAL and a professional guardian. The temporary guardian put Gretchen into a nursing home while I was away on vacation. When I got back from vacation, the GAL and professional guardian got a restraining order against me. The police threw me out of Gretchen's house. I was presented for visiting Gretchen in the nursing home. The guardian took over Gretchen's care. Gretchen was required to sit in a chair all day in the nursing home. As predicted by her neurologist, her condition deteriorated rapidly. The guardian ignored strong complaints about Gretchen's lack of activity. Gretchen was terminal by the time of the trial. She died a few months after the trial. At the trial, I testified that all the accusations against me in the restraining order are false. The judge sealed the records of the restraining order to protect my reputation. I requested copies of the recordings of the hearings on this case. My testimony regarding the restraining order was missing. All the other testimony is available. The judge was taking notes on a laptop during this testimony and questioned me personally at one point. The judge's notes appeared to be the only record of my testimony. In criminal cases, the district attorney investigates the case. The judge adjudicates the case as a disinterested party. Guardianship system is very different. In guardianship, the judge appoints the guardian. She appoints the GAL who investigates the facts of the case. The judge is responsible for oversight of the GAL and guardian. At this point, the judge is no longer a disinterested party. The judge has total control. There's no separation of powers. There are no checks and balances. Both the GAL and professional guardians seemed like lovely people when I first met them. However, I found that they have a hidden cruel side to their personalities. They kept making plausible but false statements to justify the things they were doing to me and to Gretchen. I think they were using me as a scapegoat. I never did anything to justify the returning order that determined the whole course of the case. I've had good experience with the Mystic Valley Elder Services before this case went to trial. I think they would do a good job of providing guardianship services. I think they would serve as a very good public guardian, and I'd like to recommend that they be considered for that. Thank you.
Thank you so much for your testimony. Yes, ma'am.
Good afternoon. My name is Elaine LaCroix. I've been a friend of Davis for 50 years, and I knew him and Gretchen, and everything he says is 100% true. The week before she went into a nursing home, she was ballroom dancing 3 nights a week. He was taking her out for walks every day. He took fabulous care of her, put her to a nursing home, tied to a chair. He wasn't even allowed to see her. She died within 4 months of going in there, and she would probably live another 3 or 4 years. So first of all, the assigned guardian had no training. She didn't have any idea what she should be doing and didn't do the right thing. Secondly, elder services has the kinds of people that know what they're doing, and they were kept out of the loop altogether. And third, whatever structure's put in place, and I have no idea what this bill is all about, but it needs to have guardians that are properly educated and trained and empathetic. Anyone who's spent any time with David would know he'd been in a relation with her for 10 years, and he moved in with her, left his apartment vacant so she didn't have to take care of herself because she couldn't. And because of that, they filed a restraining order against him and put her in a nursing home where she died. So I'm sure that's not the intention, but guardians have got to be the right people because they're immensely powerful to these elderly prisoners.
Thank you for that statement and corroboration. Are there questions from the panel? Thank you so much for coming in.
Testimony too.
You have written testimony. Thank you very much. Down at the end there. Eileen Boss.
I signed up twice. I'm sorry, Chair.
Okay, all right. Didn't catch that. All right, so we're now into the next. Anybody else here on guardianship? Yes, ma'am.
I was signed up for Justina's law, but I have stuff so relevant to this guardian. Could I just slip in here?
All right, this will be your moment of testimony.
I won't get to speak on Justina's law?
You can speak to both issues while you're up.
Okay. Thank you.
Oh, I'm sorry, what's your name, ma'am?
My name is Christy Klein.
You're only one person away, so.
I'm sorry, I couldn't hear you.
You were almost to you anyway.
So I came here on behalf of Justina's law, but I also was going to deliver a very strong message to all of you that this guardianship, this whole thing that's happening to our seniors and our elders, especially in light of the fact that we're all baby boomers and we're all going to be in this situation with our aging parents, is very serious. And there was testimony given today that is relative to some of the guardian abuses and whatever. So I wanted to basically testify on Justina's law, but highlight what is going on in the elderly community and with the guardianship, and reiterate what the people said about these guardianships that have no supervision or they lack the training or whatever. This is a case that's happening now, and it's one of the most outrageous, egregious things I've ever seen. However, it's happening a lot behind the scenes that we're not able to see. So I brought, and I'd like to submit to this panel, this story of a Boxford attorney, a reputable and knowledgeable attorney in Boxford who put his whole estate in order. And 2 of his daughters are attorneys. And Massachusetts has literally kidnapped him, drugged him, and put judge-appointed guardians and literally taken this man from everything that he put legally into place to happen to him out of whack. And his 2 lawyer daughters have been fighting for 6 years to be able to save their father, who's going downhill just as other people have testified of what's happened in these guardianships. So I'm going to submit this to you, ask you to look into this. I have only 1 copy that I hope you'll distribute to the panel. But I brought a dozen copies of our government drilling into this lawyer's safe deposit box and counting and stealing all of his estate. This terrifies me of what can happen to all of baby boomers' parents. This is really frightening, and I hope you'll take this so seriously and delve into this case, because it's representative of a microcosm of what's really going on behind the scenes that you're not hearing about. So with that guardian bill, everybody who's here has attested to we're long overdue, but we're coming into a crisis epidemic situation where you guys really have to start controlling what's happening to our parents. We're baby boomers. We have a lot of parents that we need to have the best of care, and they're being destroyed by this guardianship stuff being out of control. May I take 3 minutes on Justina's law?
No, you don't get 3 minutes twice. Sorry. You get another 30 seconds on Justina's law.
Wow, I sat here all
Just
day.
tell us your bottom line. Just from the line. Tell us the bottom line. Are you for it, against it?
My bottom line is irrelevant if I can't explain why.
Well, we'll take your written testimony.
Excuse me?
We'll take your written testimony on it if you'd like.
I don't have written testimony. I basically came here for Justina's law, but, and I waited hours,
You can say that we did move you forward, give you 3 minutes, and if there are a lot of other people in the room.
Okay, pretty important, but I guess I'll just say this. I shouldn't have to come here to argue that parents should have rights over their children. And until you can prove that a parent is unfit and doesn't have the best interest of a child at heart, then the government has no right to sit here and tell us parents that we can't decide our children's medical needs.
Thank you. Thank you. And thank you very much for compressing that. I appreciate it.
I'll hand this to you.
Yes, actually, to the gentleman at the end of the over there, please. Thank you so much. Now we're moving on to the next topic, which is divorce proceedings. By the way, for those who don't know, we do have a lot of testimony on the divorce issue coming next week, but we have a couple of things that come in this week. I see Jen Anderson and Dean Stenhouse signed up.
Talk right into the microphone.
It works. Pull it right up to you.
Good afternoon, Chairman. Excuse me, I can't hear you.
Really gotta do it. Yeah, put it. Let's figure out where to put it up next to you so you can really talk right into it.
How's that? Good?
Maybe. We'll see how it goes.
Yeah, as loud as you can. Okay. So, good afternoon, Chairwoman Cronin, Chairman Brownsberger, and members of the committee. I'm Jennifer Anderson, and this is Dina Stenhouse, and I will be speaking on behalf of both of us.
Okay.
Thank you for the opportunity to come here today and speak with you regarding House 903 and act relative to legal assistance in divorce proceedings, filed by Representative Paul McMurtry. In July of 2015, when this bill was first brought before you, I was unable to attend due to the fact I was at trial. A trial that lasted over 20 days, and that was just my first trial. I did write a letter to be read on my behalf, and Ms. Lanzer graciously read it for me. When I wrote that letter back in 2015, I was already 3.5 years into my divorce. Today, May 8, 2017, I am still not divorced. My husband filed just days after the new laws went into effect. I didn't know anything about the laws changing and just how damaging they could be. I'm going to quickly read to you a few examples about how the new laws affect the spouse who decided to stay home and take care of the family. Just because they chose to stay home, they should not be discriminated or penalized for doing so. When going through a divorce, it is shocking to the family no matter what the circumstances are. Number one, it should be made very clear that the new alimony laws are not a 50-50 split. It is now solely based on one's needs, which impacts the spouse that does not have their own income or a smaller income than the higher income producing spouse. Number two, the laws give the higher producing spouse more control over the divorce and finances. It allows them to drag out the divorce, draining the marital assets while being able to retain their own incomes. This is financial abuse. The non-income producing spouse is forced to incur debt to pay for their own legal fees.
and for any other services your attorney believes they need to hire on your behalf. And there is not going to be a guarantee that your final judgment will provide funds to pay off this debt. If the law is stated, another 30 seconds.
You can try to wrap it up.
Okay, if the law is stated after a certain amount of time that the higher income producing spouse will have to pay for all the legal fees going forward, you can bet that divorces would not be dragged out. A judge or a special master should try to preserve the marital assets. I can't stress enough just how dangerous these new laws can be to a spouse that is in an abusive marriage due to the fact they can't afford to get divorced. If they do divorce, all they may have is just their house, and that will be used to pay for divorce. That is why it is so important that this bill gets reviewed and passed, and information is available to everyone who needs help. Understanding, managing, and making the right decisions that will benefit their families and themselves during this process.
Thank you. Did you also wish to testify?
No, unless there were any questions.
Okay. She's yielding a little bit of her time here. You could finish your last thoughts if you wish to.
Okay, thank you. The bill needs to make it easy for anyone to educate themselves on how the whole divorce process works. Any decisions made during this difficult, stressful time will impact the rest of their lives. Thank you very much for your time.
Thank you very much. Questions from members of the panel? Thank you, John King. Thank you for your testimony. Thank you for your patience. Now we are in the next subject, which is protection and care of children. And we got next witness is Jessica Vaughn. I'm glad you got in on this one.
Thank you, and all members for having this hearing. I want to testify. My name is Jessica Vaughn from Franklin, Massachusetts. I'm Director of Policy Studies at the Center for Immigration Studies, based in Washington, which is a research institute that studies the impact of immigration on American society. And I've been with the center for more than 25 years, and before that, a consular officer with the U.S. State Department. I'm here for House Bill 869, and also, if I might use my last minute to talk about 3033. House Bill 869 is a bill that is crafted to create a loophole in Massachusetts law so that those teenagers who recently came to the United States illegally from Central America to qualify for a green card under a program that was originally designed for abused, neglected, and abandoned kids. So this would create a loophole for these newly arrived migrants even after they age out and become adults. So it's creating a loophole in state law to allow adults to be treated as juveniles for the purpose of getting the special immigrant juvenile visa. I oppose this bill because, first of all, it creates a double standard and changes the definition of juveniles specifically for this group of individuals to obtain an immigration benefit that they would not otherwise be qualified for. Secondly, it creates an incentive for young people to come here illegally and make this claim, and it rewards those who are already here who otherwise would not qualify to stay because they have aged out and because they don't qualify for any other form of legal status. The eligibility is determined by a family appropriate judge here. There's no way to verify the claims or statements that they make, and there's a lot of fraud in the program. Everyone is sympathetic to the plight of families and especially kids who've come here from Central America, but the influx has had a big impact on some cities and towns here, like Lynn, Chelsea, Milford, and East Boston, and it's been a huge strain on their budgets and schools. This bill would make it even more so by allowing more people to stay and get services. So the state should not exacerbate a problem by shielding these individuals from immigration laws. In the last few seconds, I would just like to add my testimony to others who are opposed to 3033. I've studied the 287G program for more than 10 years. There's a lot of emotion and even misinformation from today, but I would just urge you to consider the facts and experience of the program by looking at when this program was run by the Massachusetts State Troopers here in the Commonwealth. MCI has had 287G for many years. Framingham had it, the state of Rhode Island had it. On this question of fear of police, I would urge you to look at the biggest and best study ever done nationally by the University of Virginia and the Police Executive Research Forum, which looked at a 287G program in Virginia. They found that there was no evidence of a chilling effect on people becoming afraid to contact police for services because of the 287G program. The way to address that very legitimate issue is to emphasize that victims and witnesses are never targets for immigration enforcement unless those individuals are themselves also a priority on the basis of being a criminal. So,
Thank you
I'm
so
going to
much.
take your questions if there are.
Thank you very much. Representative Barrington.
Thank you for that. Just wanted to ask, those were certain questions that I'd asked, and I really wasn't able to get a very clear answer on. But you're saying that these 287Gs, there's been a major study of these to see whether it has had an impact on victims?
There have been a number of studies done on the 287G program itself by all sides of the issue. I've done them myself, but this one in particular is considered the most credible because it was done by a very neutral academic organization, University of Virginia and the Police Executive Research Forum, and in fact looked specifically at this issue of was there a chilling effect on crime reporting by immigrants because of this program, and they concluded that there was no significant effect on it. Also, the Bureau of Justice Statistics of the Department of Justice, their statistics show no difference in crime reporting across ethnic groups. I've looked at the city of Boston's crime reporting statistics precinct by precinct and matched them up to those precincts that have large numbers of immigrants living there. And I found that there is no evidence of any chilling effect that has happened because of any changes in immigration enforcement. And so I would urge you to review the research and data that's available on the topic.
Thank you.
Thank you very much for your testimony.
Thank you very much.
No further questions. All right. Also on the subject of special juveniles, GBLS panel, Ann Mackin, Ellen Von, Elizabeth Badger.
Elizabeth isn't here yet.
Beg your pardon?
Elizabeth Badger isn't here yet, so we'll just go for it. We'll just go for it.
All right. We can
She's on, Elizabeth is on her way.
We can take it later if need be. Welcome.
Good afternoon. My name is Ann Mackin, and I'm from Greater Boston Legal Services. I'm here in support of Senate Bill 825 and House Bill 869. This bill, just by way of background, was filed more than 8 years ago, and it's to help 18 to 21-year-old youth who are defined as children under the Immigration and Nationality Act. These children have a right to a classification called special immigrant juvenile if they are found to have been abused, abandoned, or neglected, or suffered something similar under state law by a state court judge. The legislation proposes an amendment to Mass General Laws, Chapter 119, Section 39BD, which would create a statutory claim through which these youth could present themselves to the probate and family court and seek the findings necessary to file an application with the U.S. Citizenship and Immigration Service for the classification of special immigrant juvenile. The last time we were before the committee was on June 24th of 2015. At that time, the committee suggested that we try to end cases in equity, which we have done and have been doing prior to that date. But practitioners have been encountering some resistance from the judiciary about the jurisdiction under the equity provisions of our state law. In November of 2015, and there was a case before the SJC which found that, and
March of 2016 that the probate and family court does have jurisdiction to present cases presented in equity for these 18 to 21-year-old youth who do have the right to this provision under this benefit to apply for it under the immigration law. Our experience for the most part is that the jurisdiction equity has not been an issue since the decision. But that said, the reasons we'd still like to move the legislation forward are that the statutory claim would make clear what the judges are to consider in their findings. The USCIS policy manual, which was newly issued in October of 2016, and then in January of this year, states what the court order needs to specify. There's also been there are 2 cases pending before the SJC right now, which can impact the bill. So what we would like to do for the moment is, the other question that came up before the SJC is what the court's obligation is to decide the findings. And if the trial judge is unwilling to decide, make the findings, or even look at the motion, the kid is blocked from exercising their federal rights. So what we're asking for right now is just that the committee retain a bill in committee. We're waiting for the decisions to come down from the SJC to see how it would impact the bill. And we might need to possibly amend the proposed legislation in light of the SJC's decisions and then bring the bill forward.
Okay. Holding on to something is something we're especially good at, actually. And so we look forward to working with you on that, and I appreciate your attention to what the committee's questions were last time around. Did you also want to testify?
Just very briefly, Ms. Mack had really covered most of what I was planning on saying as well, but my name's Ellen Densweg. I'm from Central West Justice Center in Worcester. We serve Central and Western Massachusetts. And as Anna said, I think that this bill is an opportunity for the committee to provide further clarity to judges. They have some clarity based on the Racino's decision from the SJC from 2016. But this bill provides an opportunity to provide further clarity both on the question as to whether judges may or must make findings regarding the history and development of youth before them who bring petitions, as well as what substantive standards should be used in determining whether youth have suffered a history of abuse. I apologize.
Let me stop. I don't know where this is what's happening down there. Or down, where, I think actually Mike putting my hand over was probably making a mess somehow.
But we do thank the committee for its attention to this legislation, and as Ms. Mackin has said, depending on what happens with these 2 cases pending before the SJC, it may be that it suggests amendments to the legislation to help the judges on the ground level have further clarity about these decisions.
We will struggle to hold it in committee. We'll do our best to make sure nothing happens. Until you advise us further. But we do look forward to hearing from you when the time comes, so keep us posted on that.
Okay.
Any other questions? Okay, thank you very much. Thanks for coming in.
Thanks for having us.
Bruce Hale.
Thank you. If it's okay, I'd actually request the composure to be able to speak first.
Are we addressing Senate Bill 969, or I know you signed to testify about another bill?
I should ask that.
So where are we now?
That's our question.
So yeah, I'm sorry, you are into the next subject. Anybody else on the last subject? Seeing none. We're into the next subject, which is assisted reproductive technology. Carry on.
Are we discussing Senate 969 or House?
So which, both of those, the 2 things that are in this category are 788 and House 788, Senate 969.
Am I allowed to speak 3 minutes on both? Or just 3 minutes?
Both of them, you have 3 minutes each, and you can use it as you wish.
Perfect. Then I'll start with House Bill 788, if that's all right. My name is Bruce Hale. I'm an attorney focused solely on assisted reproductive technology as a practice based on that in Newton, Massachusetts. House Bill 788, which purports to provide a mechanism for what is referred to by the bill, the adoption of embryos, which is really the donation of embryos, which is the more acceptable term. I respectfully asked the committee to reject this bill for two principal reasons. First of all, as I just mentioned, the language of the bill is a bit inappropriate as it discusses the adoption of embryos, when what we're really talking about is the donation of embryos and the ability to receive donated embryos. What does that mean? What this means is that if we have, for example, in the assisted reproductive technology process, the IVF process, formation of embryos by an IVF clinic, IVF participants are completed with making a family, and we have leftover embryos cryopreserved with a fertility clinic. They don't want to use those anymore. They choose to donate them to another party or parties for their reproductive purposes. That is the donation of an embryo and the acceptance of a donated embryo. The term that's used in the bill is problematic because it refers to adoption, which is the process that we use when we're talking about securing parental rights over a living human being, which is not the case for a cryopreserved embryo. So language is problematic. More importantly, however, it would burden the judiciary because currently the donation of embryos and the acceptance of donated embryos is handled by private contract. This is not a matter that goes before the judiciary in terms of seeking a judicial order. It's handled through private contract, the donation. And my worry is that it would burden the judiciary, slow the process down for the fertile people who are seeking this option. And most importantly, I think I would be very concerned that this could be extended, the judicial order process would be extended to gamete donation, not just embryos in the future. So with that, I respectfully request that you do not move this bill forward. Thank you.
Very good, thank you. What about your colleague? You're allowed to sit at the table.
I have no comments on that.
Yeah, that's okay. All right, so you're not speaking to that, you're speaking to the next thing.
I am, yes. Senate Bill 969. Good afternoon, chairs and members of the committee. My name is Patience Crozier. I'm an attorney with GLBTQ Legal Advocates and Defenders in Boston. First of all, I just want to say GLAD appreciates the sponsor's effort to tackle the subject of gestational surrogacy. Certainly, GLAD supports the need for statutory reform regarding assisted reproduction and surrogacy. I think children, parents, and courts will benefit from greater clarity regarding assisted reproduction and parentage. But GLAD opposes S969 in its current form. I will submit my written testimony for the committee, and today we'll just highlight our main concern. S969 provokes some critical protection for LGBTQ families without replacing it. Many LGBTQ families use assisted reproductive technology and donor sperm to create their families. One of our current statutes, 46(4)B, ensures that both children born into these families are the legal children of both spouses. This statute protects children by clarifying that automatically from birth, both of the married parents are the children's parents and not the sperm donor. Because of the statute, a child automatically has both parents on their birth certificate, and the child is legally secure to both of the parents. For these families, the current statute, 46(4)B, is simple, effective, and accessible. So 46(4)B admittedly only addresses married couples and only some forms of ART. It was enacted in 1981, and there are certainly gaps that need to be addressed, and surrogacy is one of them. So GLAD supports the need for statutory reform addressing surrogacy, which Mr. Hale, who's a practitioner, will address. But rather than adding to 46(4)B, the current bill revokes it entirely and doesn't replace it. So by doing so, the bill removes this key protection that's really a pillar for countless LGBTQ families. From our perspective, any reform efforts really should include and protect all families using assisted reproduction. And we welcome working with the sponsor and with this committee to address the concerns in this testimony and my written testimony, and hopefully amend the bill to continue efforts to address assisted reproductive issues. Thank you.
Thank you for your testimony. Are there questions? Thank you so much. I'm sorry, yes, I'm sorry.
I just had a quick question, and actually it had more to do with at first with the adoption of embryos. So the question that I have is that if, say, there is somebody who has had embryos cryogenically preserved and they decide not to use them, are they able to submit them to some sort of an adoption bank?
Private individuals may choose various methods of disposition of these cryopreserved embryos. One choice for them is they could donate them to a bank for embryo donation, or they could donate them individually to another individual or couple. And again, that is done through private contract today, rather than having to appear before the judge and seek a judicial order.
Right. So basically, they're made aware that there are these banks that they can donate them to, so they don't have to go through the courts. It's just
Yes, they don't have to.
available.
It's available. Yeah.
Okay, thanks.
All set?
We address 969 now.
You had 3 minutes to do both.
Oh, I'm sorry.
3 minutes. Just playing by the rules, okay? I enforced it on this lady over here, I'm gonna enforce it on you. You get 1 shot. Unless you want to come back again, I'll give it to you, but there's a lot of people waiting for their 3 minutes. Kate.
When you met me, I didn't think you were doing my whole name there.
Kate Walden LeBlanc?
That's right.
Yeah, right, okay, thank you.
Hello. So thank you. I am proud to be the executive director of a nonprofit called Resolve New England, which provides education, support, and advocacy for people that are struggling to become parents.
Can I point something out? You are speaking very well, clearly into the microphone. When you lean in and talk that way, everybody can hear you.
Oh, great.
Future witnesses take note.
Okay.
You're very audible.
Thank you. I was afraid. Okay, great. I'm here to speak in support of the goal of Senate Bill 969, but not the current version of it. I really sincerely applaud Senator Tarr, Senate Minority Leader Tarr, for filing this bill, because I think we share the same goal. I think it's just that, as many families experience, these are very complicated issues, and similarly, writing legislation about it is complicated as well. Fortunately, the previous speakers and myself and others are available to assist the committee members and staff on refining this legislation to make it reach the goal that it's trying to do, which is to clarify parental rights for people who maybe have to take a so-called non-traditional path to making their dream of parenthood come true. There are thousands of individuals and couples just in Massachusetts that have to use assisted reproductive technology to build their families. My husband and I were one of them, which is why I'm proud to be in this role and proud to be here speaking about this bill today. We want to support the fact that, so for example, in the case of a couple who maybe has to use a gestational carrier to become parents, it's clear that those are the intended parents. The gestational carrier is giving a very generous gift to this building of the family, but really is not the intended parent. So as is in the case with many states, technology and science has outpaced Massachusetts law in terms of clarifying some of these parental rights. And as the previous speakers, my colleagues have said, we really feel this will benefit not only the families, but also the courts, who currently have to address some of these issues in hearings that potentially won't be necessary if there's clarification in the law. So I, as my colleagues do, will get into more detail in our written testimony, and as I said, we're available to work with the committee on revising the bill. I know the senator isn't here today, but I think, like I said, we know his goal was to be helpful, but I think, again, it's just these are complicated issues, and the bill as currently written, we can't support. But an amended bill, we think, would do a lot of good. Massachusetts is really a leader in building families through assisted reproductive technology. We're actually celebrating the 30th anniversary of the original infertility coverage bill this Wednesday in Nurses Hall, if you can join us. And so we just want to add clarity and efficiency to these families.
Thank you so much. We look forward to your specific input on ways to improve the bill. Yes, Representative.
Mr. Chairman, if I might indulge you, might I ask the attorney from Glad actually just have one question. I recall a case that Glad actually handled with Potman versus Gallagher. Is that tied into this, or am I missing the point?
That's a great question, and I actually worked on the appeal in that case, full disclosure. It does speak to that.
Hartman versus Gallagher, which was a case under the paternity statutes, but it could have been helped with more clearer legislation dealing with assisted reproduction and unmarried families. So right now, 46.4b addresses only married people, but you could certainly, and many states do, the District of Columbia just passed it, Maine recently passed a comprehensive act. You could, hopefully, one would also address unmarried parents who choose together and consent to assisted reproduction to make sure they're both clearly parents, so we can avoid that kind of litigation.
If I remember correctly, the SJC was pretty clear in their decision. I thought that
Yes, well, in that decision, they did find, yes, that the non-biological mother had consented to the assisted reproduction and was the other legal parent, but obviously it took a very expensive court case to get there, so.
Thank you.
Thank you.
Thank you very much for your testimony. Moving on to topic number 8, digital assets. Mary Ann and Robert Jamian. Please proceed. Thank you all.
Thank you very much. I would like to first thank on behalf of my sister and me, Chairman Brownsberger and Chairman Cronin and the entire committee for the opportunity to testify. And I'd particularly like to extend the thanks to Senator Green, who unfortunately had to leave, but this is the 4th time that we testified, and if it weren't for my senator from Brookline, we, as a family, would not have made it as far, so I definitely want to thank her.
Am I recalling correctly when we put this bill through the Senate last year?
We put it through the Senate twice once.
Okay.
Yes. And so the issue, of course, is online assets, whether they be photos in the cloud, emails, or whatever. What happens to it after you die? And currently, there are 2 approaches, not completely antagonistic, but slightly different. The first supported by Senator Green and Senator Spisak, and the other 2, one supported by Senator Lesser and Representative Livingston, who testified previously. Now, the good news is that these bills have a lot in common. In particular, both suggest that you, as the user, while you're alive, should determine the disposition of your online assets after you die. Therefore, if through an online tool or through mentioning your will, you said, I want this stuff to be kept, I want this stuff to be deleted, whatever it is, that was not. Everyone would agree that that's the correct way to proceed, and the 2 bills do share that in common. That's for people who die with a will or who use an online tool. Now the question is, what about the 2/3 of the people who die intestate? And that's what we're here about, because that's where there's some slight differences in the approach. We believe that those assets should be inherited to next of kin just like anything else, where the executive estate is duty-bound to act in the interest of the deceased. And the other approach is suggesting that it's the terms of service, the 20-page terms of service, which no one generally reads when they sign it, should determine that. We don't think something as fundamental as a property right should be determined by the terms of service. Now, in all fairness, the reason why they say that is because they believe that the Stored Communications Act, a federal law, preempts the digital assets being inherited. And if that's true, then their approach makes sense. We disagree. But fortunately, there will now be some clarity on the issue because the Massachusetts Supreme Court took up the issue, heard it, and in a few weeks we'll know one way or the other what the status of the stored communication is with regard to digital assets. And that should inform the public policy.
The status of what will be?
The status of the Stored Communications Act with respect to its effect on the inheritability of online assets.
Stored Communications Act.
Yes. So we look forward to working with the committee. We've met with both of you before, and we're hopeful that a compromise that's in the best policy, public policy interest of all can be worked out.
Senator Brownsberger and Representative Carmen, again, thank you. I share my brother's appreciation for the committee's time. We have been here before, and this committee has supported the passage of the bills that we support. The key issue that we want to focus on today is the effect of the Stored Communications Act. There have been no court cases that have ruled on the point whether or not the Stored Communications Act prohibits an online provider from giving the contents of the account to a personal representative. This act was passed in 1986, 10 years before free online mail service was even available to the public. It was passed according to its legislative history to put in Fourth Amendment protections against government intrusion and also protections against unauthorized users. It was not put into effect. There's no evidence in the legislative history that Congress is thinking about prohibiting the personal representatives of an estate from being able to access the account after the decedent dies. And as a result, we don't think that digital assets should be treated differently than letters, diaries, or anything else. And we're happy to work with the different parties supporting the different legislation that's currently proposed, but we don't think in the interest of uniformity, which is one of the reasons that's being proposed to support the other two bills, that we should go down a road that allows the internet service providers to ultimately determine when they can provide the contents of the account to a decedent who dies without clicking on an online tool, which weren't available prior to the last couple of years, or dies without a will. Both Google and Microsoft have for years given access to personal representatives. There have not been any enforcement actions federally against them for taking that position. So whether or not you have the ability to access the contents of valuable assets in the account, financial records, pictures, health records, shouldn't be up to whether or not you happen to have a Microsoft account that would permit you to do so, or another account that would prohibit you from doing so. I think as a public policy matter, it should be the legislature that looks to see how to protect the interests of people who may die without a will and without clicking on an online tool.
Excuse me. Thank you so much for your testimony. We look forward to working with you as the information comes down from the courts. Keep us posted.
Thank you very much.
Any other questions? Thank you both so much for coming in. Thank you for your continued work on this issue. Don Sachs, Carl Zabel. All right, tell me, please correct me.
Zabo, I've given up a long time ago.
How do you say it?
Zabo, but Zabo?
What did I say?
I don't know. You said exactly that. It was perfect.
Thank you, Chairman Brownsberger and Chair Cronin. My name is Dan Sachs, and members of the committee. My name is Dan Sachs. I'm the manager of state policy for Facebook. It's always great to be back in Facebook's good birth, by the way. Facebook supports Senate Bill 885 by Senator Lesser and House Bill 3083 by Representative Livingstone on this issue. The technology industry has worked across the country, in states across the country, on this issue, and we've worked with the Probate Bar, the National ACLU, the Center for Democracy and Technology, and the Uniform Law Commission to draft language which is embodied in the Lesser and Livingstone bills, which balances user privacy expectations in their online communications and federal privacy law with the needs of fiduciaries seeking to settle the estates of the deceased. As was just mentioned, federal law, the Stored Communications Act, prohibits the disclosure of people's communication contents without their consent. More importantly, though, the disclosure of communications without an account holder's consent severely compromises the privacy of the deceased person, as well as all of the still living people with whom that person communicated. These people have legitimate privacy interests in their communications. As a result, the account holder's consent, either in a will or another document, should be required, and is required, for a fiduciary to obtain communications content. Some companies like Facebook enable account holders to decide how to dispose of their online accounts when they die through tools like Facebook's legacy contact. The lesser and Livingstone bills honor decisions made using such tools or another document such as a will. These bills would grant to a fiduciary the right to obtain non-content information. So not the contents of the email or the Facebook message, but the outside envelope information, such as to and from, date and time, even without the consent of that account holder. And that's not something that's guaranteed today under Massachusetts law. So what that means is even if the account holder has not given permission, yes, reveal my private communications and the private communications of all the still living people to me, even if they haven't given that consent, the fiduciary can still have access to critical information about who is corresponding with the deceased, the financial advisor, the bank, the insurance company, these other institutions, which the fiduciary can then reach out to and which will assist in selling the estate. The bills by Senator Lesser and Representative Livingstone represent a thoughtful, workable, and privacy-protective approach to this issue, and I would ask the committee to advance them. Thank you.
Well done, 3 minutes. Sir.
Thank you, Mr. Chairman. Co-chair, my name is Carl Zabo. I'm Senior Policy Counsel for NetChoice and E-Commerce Trade Association. I'm also an adjunct professor of privacy law at George Mason. We've been talking about this issue for 4 years, and now is a great opportunity for Massachusetts to finally get it right. That's why we support SB 885 and HB 3083. It strikes the right balance, and it's a compromise bill between the privacy interests of the deceased, the needs of the bereaved, and federal law. Now, we didn't want to go out there and just say what we believe people want. We wanted to actually know what they wanted. And so we actually went out and polled people across the country, and these poll results are available online with crosstabs and questions. And 4 to 1 said the privacy of their communications are more important than giving access to their next of kin. Over 70% of Americans say that their communication should remain private unless consent is given, and less than 15% think that the estate should control. So when they die, those choices about who gets to read or access emails should be theirs alone. That's why over 30 states, and this map is also included in the testimony that we submitted, over 30 states have adopted laws like SB 885 and HB 3083. These include California, Connecticut, New York, Oregon, Virginia, and Washington. Now is the right time and the right opportunity for Massachusetts to strike the right balance. It's for these reasons that we support SB 885, HB 3083, and we're available to get into the weeds if you like. Thank you.
Very good, very efficient. Thank you. Questions?
Just one, Mr. Chairman. Thank you. In the absence of this bill right now, can you just give us a landscape of what's happening right now in Massachusetts when it pertains to this? Do you know?
Thank you for the question, Representative. I believe that right now there is no legal right, there's no statutory right, for any next of kin or fiduciary to go to a communications provider and demand any information. So, there have been theories that have brought to the courts under other sources of law, like contract law and property law. To my knowledge, this has never been successful. There's now over 30 states that have a statutory right that companies like Facebook comply with. And if I mention, Mr. Chairman and Madam Chair, I neglected to mention, spoiler alert, I believe that some other stakeholders might suggest language that is slightly more expansive than the Lesser and Livingstone bills, which also gives the same rights to other types of fiduciaries for living but incapacitated persons. And Facebook supports that language as well, and would be happy to work with the sponsors and those stakeholders on that approach.
Thank you for that. Yes.
Just very briefly, Mr. Chairman, thank you. Just a question. Isn't this a fix Facebook could enact on their own in the user agreement?
Sorry, you faded out for a second there?
Sure. Isn't this a fix that Facebook could, as far as Facebook goes, take care of itself in the user agreement?
Representative, I'm not positive whether that would happen or not, but I think I just laid out why we don't think that that's a good idea. We think that people want to affirmatively decide what happens to their online communications when they pass away or become incapacitated. And so that's why the tool that we offer, called Legacy Contact, which I encourage you now Facebook users to look at, that's why that tool allows people to make that decision for themselves, and we do not impose a blanket decision in our terms of service agreement on that.
And Mr. Mayor, companies are coming into this space to kind of fill a vacuum if an online service doesn't provide such a tool. One such company is Directive Communications Services, which is based here in Boston. And they're coming online to have kind of a one-stop shop where you can make decisions on an account-by-account basis. They're working with trusted estates attorneys and online service providers to make this a seamless and easy process.
All right, thank you so much for your testimony.
Thank you.
Joe Yearwood, Boston Bar Association. Welcome. Thank you for your testimony. You're here also on the digital assets stuff.
Yes.
Great. Please proceed.
Good afternoon, chairs, members of the committee. Thank you for your time this afternoon. My name is Mark Bluestein. I'm a lawyer at Ropes & Gray here in Boston. My areas of practice are estate planning and fiduciary law. I'm here to talk about the 4 bills that are pending before the committee that address access to email by personal representatives. I am speaking on behalf of the Standing Committee on Massachusetts legislation relating to wills, trusts, estates, and fiduciary administration. This Standing Committee was formed 3 years ago by the same people who put together the ad hoc committees that review the Uniform Probate Code, the Uniform Trust Code, the Uniform Principal and Income Act, and the Uniform Investor Act, and recommended all of those for enactment in Massachusetts. In 2014, our standing committee appointed a subcommittee chaired by Colin Korzik to review the Uniform Fiduciary Access to Digital Assets Act, which was promulgated by the Uniform Law Commission. And that subcommittee reviewed it. The act was revised by the Uniform Law Commission, as Colin will explain, and that subcommittee and our standing committee has now approved and recommended the act for enactment in Massachusetts with very few changes. That act is not, as was already mentioned, all that dissimilar in some ways from the bill sponsored by Representative Livingstone, but it goes further. It covers access to digital assets by all kinds of fiduciaries, so not just personal representatives, but also trustees and agents under irrevocable power of attorney, and also conservators. And it covers all digital assets, not just email. And we believe that this is a very, very urgent area for legislative action, because as was also mentioned, there's no current ability for a fiduciary to access any kind of digital assets under Massachusetts law. There's certainly been a lot of dispute with the industry about the Stored Communications Act, as was also mentioned, and about how much that limits the ability of internet service providers to provide information. But the revised Uniform Fiduciary Access to Digital Assets Act was worked out as a compromise that, at least as an immediate step, would allow access by fiduciaries. And the Standing Committee believes that that's very important and that there's some urgency here. The urgency is well demonstrated by the fact that the Uniform Law Commission issued the revised version of this act in the middle of 2015, and already over 30 states have adopted it, which may be a record for adoption of uniform acts. Anyway, I'm going to pass the microphone along to Colin Korzak.
Okay. Thanks, Mark. Good afternoon, everybody. Thank you for your patience, and thanks for giving us a few minutes today.
Patience.
As Mark mentioned, I was asked in the summer of 2014 to chair a subcommittee. The Standing Fiduciary Committee asked me to chair the subcommittee to look at the Uniform Act promulgated by the Uniform Law Commission. That Uniform Act was the Uniform Fiduciary Access to Digital Assets Act, lovingly referred to as UFADA. The committee that I formed was comprised of 9 members of the Bar Associations, Mass Bankers Association, and the trial court system. We met repeatedly. We were about ready to come out with our report out in favor of UFADA when the Uniform Law Commission called me and said, hang on a second, we've got a revision that's going to be coming your way pretty soon. So that came in mid-2015. The reason why, you ask, why was the revision already required to UFADA, which became RUFADA, revised UFADA? Well, what happened is UFADA got filed in a number of states across the country. Basically, the technology industries came forward and had issues with UFADA and basically contested UFADA wherever it was filed and defeated it wherever it was filed. The Uniform Law Commissioner said we need to go back to the drawing board. And so as a result of that, in conjunction with and support by the technology industry, the compromise, as Mark mentioned, RUFADA came out. So my committee went back to work late in 2015, looked at RUFADA, and we reported out in April of 2016 in favor of RUFADA. We've submitted written testimony, which includes our report out, the act itself, so I won't go into any detail. Other than to, again, echo what Mark said, that it's important, I think it's a compromise, it's important to get something on the books, because as fiduciaries, to sort of put it in an oversimplification, fiduciary's job, amongst many other things, of course, is to ascertain assets, collect assets, preserve assets, whatnot, and fiduciaries, we're running, when I say fiduciaries, as Mark mentioned, we're talking personal representatives, trustees, attorneys in fact, and conservators. Those are the 4. We're running into issues with the technology industry folks and gaining access to those digital assets. So as a result, that's why we came up with RUFADA. And I think Joe is going to talk a little bit about sort of the importance of the having uniformity and why we think that it's important to keep this the way that it is. Thank you.
Before you continue, RUFADA is which of these numbered bills?
It's none of the above bills at this point. Our hope is, and part of the reason for being here today is that we're hoping we can get some of these bills to incorporate sort of the whole RUFADA.
So to follow up on that, just as a preliminary point, as Colin mentioned, we have submitted the language of the revised Uniform Act for today's consideration, so you'll have that in front of you. So again, I'll try not to be duplicative. My name is Joe Fearworth. I'm a partner at the Boston law firm of Hemingway & Barnes, and my practice includes advising fiduciaries and also serving as a fiduciary myself in these various capacities that we've mentioned. But I'm speaking today as chair of the Trust and Estate section of the Boston Bar Association. And I'm happy to report that the BBA has endorsed RUFADA, the Revised Uniform Act, as has the Massachusetts Bar Association and the Massachusetts Bankers Association. So since I've been involved with trying to shepherd RUFADA, the Revised Act, through the BBA, I can let you know that we have had extensive conversations within the BBA about the language of the RUFADA. That language has been vetted by multiple committees. There were questions raised about privacy concerns and other concerns along the way. And in the end, what we wound up with was widespread consensus that the language of the RUFADA was the way to go for Massachusetts, given the concerns that others have spoken about. So there's broad support for that, not only amongst us attorneys who advise fiduciaries or act as fiduciaries, but amongst other attorneys from different practice areas who are more focused on businesses or privacy concerns. And I think it's fair to say that that broad support comes about because RUFADA provides 3 things, really. It provides certainty, uniformity, which Colin mentioned, and this comprehensive nature. So I think it was mentioned before in response to the question that there's currently no statutory language whatsoever in Massachusetts governing digital assets and access by fiduciaries. So as a result, there's a lot of uncertainty amongst the bar, and I echo Mark's thoughts that there's an urgency in this. Lawyers like certainty, and our clients do as well. RUFADA will enable us to plan for our clients in a uniform way, so that the plans we put in place won't just be good in Massachusetts, but will also travel to different jurisdictions that have adopted this RUFADA language. So that will be helpful to us and helpful in having these discussions with our clients, because we have all the backdrop of the Uniform Law Commission and all the support of that we can use. We know, the other thing that we know is that we know, as Colin mentioned, that this language has been vetted by the technology industry, has been accepted. You've heard from the representatives before us that they would support this, and we look forward to working with them on this. And finally, the major thing, next major thing is that RUFADA does present sort of a comprehensive look at this issue. So for those 4 categories of fiduciaries that we've mentioned, it has rules applicable to all of them. So it's not just for personal representatives of the state. So on behalf of the BBA, we would urge the committee to move this forward in the version of RUFADA under the language that's been submitted to you. Thank you.
Questions? I have a couple, I just want to get clear on this. So the first bill we had was, is there kind of a spectrum of positions in here, one end where you want people want the heirs to have access, sort of like other access versus this more privacy orientation? We heard that between the Jamians on the one hand and then the Facebook panel on the other hand. So there's that kind of dichotomy of approach. And where does RUFADA sort of fall on that?
Essentially, I think it's as much as it can be, it's a compromise between, if left alone, you've got the 2 extremes. This is as much getting them together as you can. And again, it was, as I mentioned before, it was the Uniform Law Commission going back to the drawing board with the technology industry, with the fiduciary folks, and saying, what can we collectively live with here, as Mark said, to sort of advance the law a little bit.
So Senator Green's bill is a bill that would simply allow an administrator or executor to have access to digital assets in the place of the decedent. That may well be beyond the scope of what the Stored Communication Act allows. That question is indeed before Supreme Judicial Court right now. But of course, as a question of federal law, the decision of the SJC is not ultimately going to be controlling. And it may be many, many years before we know what the answer is to that legal question. And so if Senator Cream's bill is enacted, there will likely be legal challenges in the federal courts, and that could lead to some delay. In addition, Senator Cream's bill is very narrowly focused on email and on estates. And so the benefit of revised RUFADA is that it focuses on all manner of fiduciaries. And it also adopts an approach that the tech industry believes is consistent with its view of the Stored Communications Act, which means there's not going to be litigation. Now, the downside is that indeed it does require an act by the decedent or the person who creates the fiduciary relationship to say, I consent to the release of these materials, either through the online tool or through a will or a trust instrument or a power of attorney. But with that consent, we've got full access. So we get much of the way toward where we want to be with revised RUFADA. Revised RUFADA doesn't necessarily exclude the possibility of executors having rights beyond that scope if indeed the courts find that the Stored Communications Act allows them to have those rights. And we don't, need to foreclose that possibility.
Thank you for that clarification. Appreciate it. Look forward to hearing more what you have to say on that. So I believe that brings us back to immigration. A little bit ahead of schedule. And do I have Karen Bauer over here? Please proceed.
Good evening, good afternoon, actually. Thank you for letting me speak. My name is Karen Bauer. I'm a resident of Belmont, Massachusetts. I speak today on behalf of the American Human Service Committee, which is a 100-year-old organization which deeply concerned with the rights of immigrants. I'm offering support for age 30 and 33. And I ask you, what is a police officer's most valuable asset? Or a town or city police department's most valuable asset? I believe it is trust. And trust is at the root of the social contract we as residents of Massachusetts have with our police. And trust is reciprocal. This binding trust protects citizens and the police alike. In many places in America, the social contract between the police and the residents is fraying. The costs are real. For example, a child citizen of the United States fears attending school and coming home to find a parent simply gone, lost into deportation proceedings. Or a sibling born outside of the United States faces deportation with a U.S. citizen sibling wondering whether his or her sibling will be home at the end of the day. Or a mother in a visa overstay due to a domestic violence situation in the home. She's afraid both for herself and for her children. And these examples I'm citing, they are taking place in Belmont today. And these people, they are not concerned about 287G agreements. They are confused as to what they would mean. They are afraid of the police. They're afraid of anyone in uniform at this point. And I think in order to prevent further erosion of trust between the residents of Massachusetts and their local police, I ask for your support at age 30-33. In order to serve their communities, police should not be asked to enforce federal immigration law. Let ICE expend federal resources and accept all the attendant potential liabilities associated with federal immigration laws. Collaboration between local police and ICE under the 287G program increases our trust in our local law enforcement. And trust is an officer's and a department's most valuable asset. I would just say that as an individual who has been studying the history of immigration and deportation in this country, I believe we are standing at a moment of incredible import. And I don't want to be on the wrong side of this. Like if we look at the Fugitive Slave Act, that people used to be fined and imprisoned if they wouldn't return slaves. Are we going to go there? Is that what our government is going to ask of us? Is that what Sessions, Attorney General Sessions means when he says aiding, abetting, or assisting? If that's what he means, let me tell you, I'm afraid for our democracy, this is an issue that will define us. And please, please, look out for the rights of immigrants. That's all of us. And thank you again for your time and letting me speak out of line. Thank you.
Thank you very much, and good luck in telling tonight. I'm going to turn it over to my co-chair for a couple moments to be right back.
Jennifer Brody. Maggie Sullivan. Judith Goldberger.